Good morning, WTOB listeners. This is For the Record with Greenwood Law. I'm Dylan Greenwood. Joining me is Harold Eustache. And today we're going to be talking about different potential criminal liabilities that come from your children and having your children and making sure that your children are attended. You know, last week we were talking about some of the dangers that teens and our children face virtually, online, on the internet. And we've got a lot of great feedback about that. A lot of people were very appreciative about what we said about that. So thank you, first and foremost. We always appreciate that here on For the Record with Greenwood Law. And it seemed like the goal of that video really hit home. Keeping with that, though, you know, one of our themes was, you know, be mindful of what your children are doing, you know. And there are ways in which that if you're not mindful of what your children are doing and it goes to the extreme where you are truly neglecting one of your children, then that can land you with possible criminal liability as a parent or guardian. And I say that you don't have to be a parent. You just have to be someone in charge of the children. And if you leave them or put them in harm's way or something, then you can absolutely incur criminal liability for that. And the other reason why we're bringing this up is because, you know, we're about to get our kids back in school. And up until this point, there's been a lot of virtual learning, but there's been a lot of aspects of people's lives that haven't changed where they've still had to go into work. And it is untold, and we have no idea just how many of our children were perhaps left at home, unattended, for them to do virtual learning or whatever else because of obligations that parents had and with their jobs or whatever else. And that's an all too common scenario, isn't it, Harold?
It really is. And it's a tough thing for parents to deal with, but it is a common scenario, and unfortunately we do see it. We see it charged quite often. Various different reasons that it's charged, but ultimately there's two North Carolina criminal offenses that kind of cover this sort of behavior about a guardian or a parent or an adult, essentially, that can lead to either some sort of substantial risk of injury or delinquency. The first one is really kind of explained by the title of the statute itself. It's called contributing to the delinquency of a minor. And in that statute, it is essentially any person, any adult who aids a minor in being involved in an action that could lead to the minor's delinquency. Now, that's very broad language and can encompass a whole lot of different things.
Quite broad. I mean, think of all the times you've been out and around your child and they've been a bit on the delinquent side, and whether or not you step in, you know, arguably you've contributed to that, depending upon how you reacted. But that's not really what the statute is about. The statute really tries to look more about neglect, some types of abuse, although that does fall within its own statute of child abuse. I would say that it would be abuse that falls just below the standard of misdemeanor child abuse or even felony child abuse. But it's really it's more about putting a child in a potential situation for harm to come to that child.
Right. Like, for example, one way, a couple ways I've seen it charged quite a bit is, one, if an adult, let's say, aids a 13-year-old by letting them skip school and they smoke marijuana together. That is aiding to the delinquency of a minor because they're missing school, but also they're doing something that they could be adjudicated delinquent for, and the adult is making an actual action to aid to this delinquency, and that's kind of what you see. Or another one would be, unfortunately, we've seen some mothers or fathers who take their children into a retail establishment and have their children conceal goods. That is also, contributing to the delinquency of a minor, because concealing goods is a crime in and of itself. and then that adult is having a minor do that. So that's a couple ways for folks to think about how you would see this sort of thing charged. That's just two ways. I mean, there's a million other ways.
Another way I can think of is, and it's about to come to a head because the summertime is right around the corner, we're starting to heat up, is leaving a child in a car.
Right.
And really that can go for if temperatures are too warm or too cold. And the car isn't on, they're left unattended for a substantial amount of time. And the statute doesn't really put some time limit on it. But I think we all know that, especially summertime here in North Carolina, it gets real hot, it gets real humid. The interior of a car, whether it's for a child or for a pet or whatever might be in that car, the temperatures inside a car can get super hot, super quick. And so I think that's why the statute, it wasn't necessarily, codified with the intent of who knows how long it takes in a car for a child to get too hot. But I think it was left open for interpretation because there were all these potential scenarios that parents run into with their children, to take all of that into account. So just, that's just something to be mindful of as things are heating up. It's a whole lot more worth it to take your child with you into wherever you're going than to leave that child out in the car, because if you do, then the criminal liability of it all is probably the least of your concern.
Right.
When it gets down to it.
Those are sad scenarios, and we're going to get to some of that. With contributing, one of the important things to think about, and something the courts have talked about, is whether or not, it doesn't matter whether or not the juvenile ends up being adjudicated delinquent. And so what that means is it doesn't matter that the juvenile gets in trouble. The juvenile doesn't have to necessarily get in trouble for the conduct for an adult to be charged with this crime. So that's important.
Just like the statute says that there doesn't have to be a physical injury.
Right.
Physical injuries are taken into account.
Right.
But putting a child in a situation where there's a substantial risk of a physical injury is enough as well.
Right. And that gets to misdemeanor child abuse.
Yeah, that toes the line back and forth.
Misdemeanor child abuse is that, we talked about the first statute that you can be charged under. The second statute that you can be charged under criminally is misdemeanor child abuse, which is an A1 misdemeanor, which is one of the most serious misdemeanor we have in North Carolina. And essentially, a person can be found guilty of that as a parent or guardian of a child who's less than 16 and either 1, inflicts physical injury, 2, allows physical injury to be inflicted, or 3, creates or allows to be created a substantial risk of physical injury by other than accidental means. That's the problem that we were talking about there. As far as inflicts physical injury, that's one where we think about where's that line. This is the one we see charged the most, is where's that line between discipline and child abuse. And so that's an important line for us.
So I know many parents out there, Harold, use corporal punishment when it comes to disciplining their children. And I know that North Carolina law and case law, they take into account spanking.
Yes.
And it's allowed pursuant to the law. Just how far can that go, or what have the courts said about that specifically?
The courts do have quite a bit of history talking about spankings, and it's an important issue in North Carolina because there are parents that fall on different sides of how they think about spanking. But the more recent cases have allowed spanking, and generally the courts have allowed spanking. The line is, so for example, under the first prong, inflicts physical injury, as long a spanking is going to inflict some sort of pain, but as long as it doesn't inflict lasting physical injury is what the courts have really said. So, if you take out a whip and it scars the child permanently, that's going to be misdemeanor child abuse and maybe even felony child abuse. But if even with a belt or your hand or whatever, and a child gets spanked and it's only to cause some sort of pain or whatever, that is not a criminal offense and hasn't been seen that way. So it's the line of, are you leaving permanent scarring? Really, it's kind of the best way to think about that line for spanking.
So yeah, I mean that would be any kind of physical injury that would leave permanent scarring. Cigarette burns would be that. A whip that would leave scar, like you said. Any kind of weapon that's used, anything like that. That punishment goes way too far as what is looked at by the courts. And it isn't just, I mean, spanking is the most common way, but basically courts have said you're allowed to discipline your children and it leaves it open for interpretation, if I remember correctly, just how far it goes, as long as you don't leave those lasting marks.
Right. Another interesting part of this statute is the second part of the statute that says allows physical injury to be inflicted. And that we see charged in situations where a parent puts a child in a position, a lot of times where somebody else inflicts serious injury. So, for example, let's say there's a parent at a home and they have a child and a new boyfriend or girlfriend comes into the home. It's kind of the way we typically see it charged. And new boyfriend, has some serious abuse to the child. And mother knows of new boyfriend's past, boyfriend's behavior, all this sorts of stuff. Now, boyfriend may be charged with a serious offense, but this mother could also be charged with misdemeanor child abuse for allowing a physical injury to be inflicted because of various factors that the person could have known about.
Yeah, absolutely. And I mean, that just comes down to the fact that, as a parent, there are certain expectations. You have, we've talked on this program before that you have legal and constitutional rights to your children, but with that, you also have legal ramifications for if you don't follow through on your duty, your constitutional right to be a parent. And there are, we talked about all the civil ways in which that can come about before on this program, but, these are the criminal ways where, if you are putting your child in harm's way, if you're doing the harming, you can certainly be charged. And certain entities like school, therapists, any kind of medical professional, actually lawyers, we have a duty to tell if we're made aware of something for a child. That is one of the things in which those duties of confidentiality and potentially attorney-client privilege, the law say can be broken for the purposes of protecting children. Because when it gets down to it, you can assume typically that the law, especially here in North Carolina, is going to do whatever it can to protect a child. And this is just one of the many ways in which that can happen.
And so that is an important, and we see this second prong interact with DSS a lot. And some of this stuff is not to be confused with DSS. Just if somebody is if DSS says they're neglectful or delinquent with a child, that doesn't necessarily mean they're going to be charged. So, but then that's a whole nother topic we can get into another day. But this third prong is one that's actually probably used the most in misdemeanor child abuse and has a lot of nuance to it. So we can get into that in just a minute.
If you're just joining us here on WTOB on For the Record with Greenwood Law, Dylan Greenwood here with Harold Eustache, and we've been talking about contributing to the delinquency of a minor and child abuse issues here in North Carolina. And unfortunately, it's more of a prolific problem than what we would care to see, honestly. That being said, there are many times in which we've seen charges where it's overblown or it's wrapped up into some sort of civil family law issue, and it feels like charges are used as some sort of bargaining chip. That's not what these laws are here for. And there are very much substantial and serious risks that our children face each and every day. And a lot of times our children that are facing those, we're receiving protection by going to school because the school might see something, become aware of something, have a duty to report, and then all of a sudden, things are put into place to potentially protect that child. Obviously, in the midst of COVID, that's been less and less because there's been e-learning, and it's a lot harder to see some of that stuff. But there are resources out there. One of the biggest ones here in Forsyth County is Parenting Path. One of their big things that they do each and every single day is to try to protect our children here in Forsyth County. They do it through activism that they do, but they also do it through education. And they will help educate parents about different tactics that they can use to parent from, toddler years all the way up to their teens. But, Harold, you mentioned that, one of the more common ways in which someone can be charged with child abuse is whether or not they created or allowed a substantial risk of physical injury to be created surrounding that child. Do you care to elaborate a little bit more about that?
There's several cases in North Carolina that really delve into this third prong of the misdemeanor child abuse statute. One of them is called State v. Watkins in 2016, and in that case, a woman goes into the sheriff's department in Madison County and begins talking to some sheriff's deputies there, gets into an argument inside the sheriff's department, which is generally a bad idea. And it was January, it was 18 degrees outside, it was sleeting and snowing, and she left her 19-month-old in the vehicle with one of the back windows halfway down and the vehicle off. So one of the sheriff's deputies notices this, and she ends up getting charged with misdemeanor child abuse, and she ends up being convicted. And the court really looks at whether or not the state put enough substantial evidence to show that there was the conduct of this mother allowed for substantial risk. And the court said that it did. The fact that the window was halfway down, the fact that the temperature was so cold, and the child was left unattended for over 5 minutes could have allowed a substantial risk of physical injury from that sort of conduct. Another case in 2018, and this was in the news, and it's a tragic case in which a mother left I believe a back door, sliding door open, went to the bathroom for 5 to 6 minutes, had a 2-year-old, and the 2-year-old went into the pool and drowned and ultimately passed away very sadly. And the mother was charged with child abuse and I believe was also charged with involuntary manslaughter. But as far as child abuse, the courts did find that she allowed there to be a substantial risk. And the reason wasn't just because she went to the bathroom and left her child unattended. That happens every day in America with parents that need to go to the bathroom. It was because she knew there was some testimony and some other things that happened that she knew that the child had a proclivity to go outside a lot. And this had happened before, where the child had wandered outside whenever the child was unattended. The parent left the back door open, and that the pool itself was
an attractive
nuisance for the child, and really was luring the child in. So all those factors led to her being convicted. I don't think she was convicted of involuntary manslaughter. I'm not exactly certain, but I don't think so. But ultimately, that's these two parents were convicted, and in our practice, we have seen parents get charged for less, to be honest with you, for misdemeanor child abuse, for leaving children in cars unattended and leaving children at home unattended. What I will say is, it is just leaving a child unattended. It technically is not enough to say there's a substantial risk, even though it does get charged that way. It really should be something else. There should be some other factor, a pool, 18-degree weather, something else to create a substantial risk, not just you left the child. So, the unfortunate part is we just see it charged that way a lot.
Yeah, and you mentioned, the thing about pools. They are codified in North Carolina law that it's a blanket attractive nuisance.
Right.
It's not even like, it's a situation in which, you've got to try to prove that it is, or you're concerned that it is. Basically, the law looks at it. This is an attractive nuisance, and if you have a pool, you've got a duty to do things to protect it, not just for yourself, but for anyone else around, because pools are something that are going to attract children. It's just the way it is. I mean, I've got a little one right now. You take him to the pool, he will jump into the pool, will not care. He just trusts that you're going to get him. And that's, kids have that mentality that, nothing's going to happen to them, and you got to account for that. So with that issue, there's this criminal liability, there's a lot of civil liability. There's criminal liability in that case because that was the parent's pool and the parent knew that about their child. Don't think that if you are the neighbor of someone with a child that all of a sudden you're going to get charged necessarily with misdemeanor child abuse. It's not like that. You could be sued.
Tort.
Certainly you could be sued. But when it comes to criminal liability, it has more to do with the fact that they were the parent. And that's the big thing. Harold, one common thread that I heard in both of those cases, you had a 19-month-old and you had a 2-year-old. Okay. So both of them toddler age, young, not fully adept at stuff yet. Don't understand a lot of consequences about their actions necessarily. Those cases, I would say, are pretty cut and dry, or pretty clear more often than not about whether or not it's contributing or whether or not it is misdemeanor child abuse. I think the court would look at or have special attention to cases involving toddlers.
Absolutely.
I know a lot of the questions we get in these cases is, well, isn't there some sort of age cutoff? Once they hit 10, 11, 12, 13, teenager, surely at a teenage years, I don't have to worry about the statute, right? And the statute, if you go through all the elements, I've never noticed any sort of age cutoff, and I don't know of any potential legislation that there's an age cutoff other than being a minor, and that age cutoff being the age of 18.
Right.
So 17 years and 364 days old.
They're minor.
They're a minor.
Yep.
And once they turn 18, then all of a sudden these don't apply. But up until that point, how do you think a court looks at that age issue?
The court looks at it holistically and weighs various factors. You're right, there is no age cutoff in North Carolina. There isn't a statutory one, and the courts haven't made one. There are states with age cutoffs that apply, and they kind of range throughout the United States. And if you want to look that up, they're interesting. But in North Carolina, there is not an age. What the courts really look at is just a myriad of different things. So if you leave a child at home, they're looking at, okay, the age of the child, of course, looking at how far away the parent is from the home. Did you go 1 mile away, or are you, several towns away? You're looking at other substantial risks in the home, an unlocked weapon, fire hazards. I mean, what's the environment in the home like? How long were the children left alone? All those things play into whether or not a person could face criminal liability for leaving their child at home unattended. But as far as age, it varies, and it varies about knowing, also a parent knowing their child. So, my daughter at 12 was more capable of watching another child, whereas my 12-year-old son is absolutely not capable of watching.
My wife and I talk about all the time how she was babysitting at 10 years of age. And I mean, she's an extremely mature person. I trust that those kids were just fine at 10 years of age. But, times change.
Right.
And you got to think about that too. I mean, I'm not going to give her age away, but there's a different time period from when she was doing that until now. Mm-hmm. You could argue that there's a lot more dangers out and about that are prevalent that could potentially face a child on a day-to-day basis.
There are, and it seems like both law enforcement and the courts have viewed this differently. That they've just been charged more when children are left unattended. I mean, decades ago, children were routinely left unattended, mm-hmm. and that was just par for the course for parents in the United States. And it just feels like at this point, parents have to wonder about that much more, about kids being unattended. And it is something that, unfortunately, we do want parents to think about. We know that given COVID and given everything going on in our society, it can be very difficult to find a babysitter or find a way to work with virtual learning and all this stuff. But it is something to really, really pay attention to, because it is something that is charged sometimes.
And I'll just say, I know babysitters get expensive, but they're a whole lot cheaper than we are.
Right.
If something comes about.
That is true.
I'll just say that.
And that's partly because the prosecutors they take this charge very as
Absolutely.
They should. They take this charge very, very seriously. Mm-hmm. So it's not something when somebody is charged with misdemeanor child abuse, it is not seen as just a small charge. It is definitely seen as a very, very mm-hmm. important charge, and the state of North Carolina takes it seriously.
Well, everyone, thank you for joining us this morning on WTOB for the Record with Greenwood Law. We always appreciate you joining us. And don't forget to join us next week on Sunday at 10:30 a.m. Back here on For the Record. And we're going to be talking about pretrial release in North Carolina. And it's something that's been an odd yet hot topic, even prior to COVID happening. Certainly in the midst of COVID, because we have confined populations that have a proclivity to get infectious diseases easier than other populations. And there was a pretty big lawsuit that happened in an almost neighboring county in Alamance, in which it was very much scrutinized their pretrial release procedures.
Right.
So we're going to be breaking that down and just giving you guys a better understanding of just how that works. But before we go, Harold, kick them off with that Greenwood Law Bill of Rights.
First, I will not represent myself in a court of law. Second, I will not do law enforcement's job for them. Third, I will not make statements when stopped by law enforcement. Fourth, I will not consent to searches when asked by law enforcement. And fifth, I will not be my own star witness for the prosecution. Remember, it's important to know your rights. Stay safe out there. This is For the Record with Greenwood Law, signing off.